Good afternoon and welcome to this Garden Court webinar. This afternoon we're going to discuss some of the legal developments in trafficking and modern slavery. My name is Stephen Galliver-Andrew. I'm joined on my left by Nicola Braganza KC and to my right Ronan Toal. We're all barristers at Garden Court Chambers in the Immigration and Public Law teams. I'm chairing this evening and Nicola is going to be talking about challenging delays in the NRM in the determination of trafficking status. Then Ronan is going to take over and is going to talk about challenges to public order disqualifications from the NRM process. So before we begin with our speakers, we'll just do a little bit of housekeeping. So first of all, this webinar is being recorded. We will send out slides and a link to the recording for everyone who's registered to attend after the event. The event will also be available on our YouTube channel. We will do some questions and answers. We'll group those together at the end of both of the talks. And finally, just before we go into the substantive part of this afternoon's presentation, just to flag a couple of other events that are coming up at Garden Court. So on the 18th of July, between 1 p.m. and 2 p.m., we have a webinar, Judicial Review and Mediation. Do they go together? Then on the 18th of July from 5 p.m. to 6:30, we've got a webinar on the Renters Reform Bill. And then on the 25th of July at 5 p.m., we have another webinar on the need for lawful notice prior to eviction travellers. And that's in relation to SO and Thanets. So without further ado, let me introduce our first speaker. Our first speaker is Nicola Braganza, KC, Garden Court Chambers. And Nicola is recognised as a leading barrister specialising in equality and discrimination law, as well as public law and human rights. Her broad practice spans areas of employment, education, community care, immigration and asylum law. She's got considerable experience bringing complex and large-scale challenges against the state, including civil claims for damages on behalf of individuals and on behalf of groups. She has particular expertise in representing highly vulnerable adults and children, including victims of trafficking and modern slavery, and those held in immigration detention. And this afternoon, she is going to talk about some of the endemic delays in the NRM process and the delays in determining status for individuals within the NRM system. With that, I'll pass over to Nicola.
Thank you. Thank you, Stephen. Hello, everybody. Thank you very much for joining. It's good to see so many of you joined up and hopefully even more of you will watch our recording. As Stephen was saying, I'm going to be speaking about NRM delays. And what I'm going to do in terms of how to run a delay case and pass on to you tips that I've learned from them is to go through some current key statistics and then take you through the legal framework and then give you some detail about the main cases on delay in the NRM process. And finally, to ask the question, where do we go from here? So first of all, some key statistics, and you'll find these statistics on the link that I've put at the bottom of the slide. And the reason I've set these out is to really bring out how dire the delays are currently and have been for a number of years in the NRM, and also to provide you with the evidence when you're running your own delay cases with this source of information which sets out the context and the background in which these claims can be then brought. So the latest update shows that in the quarter from January to March this year, just under 5,000, so 4,746 potential victims of modern slavery were referred into the National Referral Mechanism. That's a 7% increase compared with the previous quarter of October to December last year, 26% increase from that quarter last year. And that number of referrals is at its highest since the NRM began in 2009. 79%, that's 3,768, was sent to the SCA, the single competent authority. And you'll know the IECA, that's the Immigration Enforcement Competent Authority, dealing with adult foreign national offenders, those detained in an immigration removal centre, those in the third country unit, the inadmissible process. which started in 21, dealt with 21% of the referrals, that's 978. The other key statistics that they set out on that link on that government website is that most referrals were Albanian nationals, then followed by UK nationals. The combined competent authorities of SCA and the IECA recorded their highest quarterly numbers since the NRM began, with 3,500, just over 3,500 reasonable grounds decision, that's the initial decision, and then 2,275 conclusive grounds decisions issued this quarter. In terms of the outcomes, just over half of those referred in received a positive reasonable grounds decision, and of those, 3/4 a positive conclusive grounds decision. Now, in terms of delay, that gives you an idea of the statistics of referrals and eventual outcomes. The average time taken from referral to conclusive grounds decisions is 566 days. Now, that's slightly down on 641, and in a moment I'll take you to the breakdown of how those are arrived at. Average time for the single competent authority was 654 days. Average time for the IECA, 352 days. And obviously IECA was shorter because they're dealing with far fewer cases. The statistics also set out that times do not reflect the waiting time of all cases within the system. Some take longer than that. And I wouldn't be surprised if many of you have dealt with longer delays, far longer delays than that. So I've set out here, really for your benefit in case you are citing the statistics, the overall view, and that's by both competent authorities. And then I've broken it down so that it's more legible in the following slide. So bear in mind that these time periods are the combined figures. So they'll be slightly skewed because of the extent of the discrepancy between the SCA and the IECA. But if you have a look, I've highlighted and you see how dramatically those delays have gone up in the first period from 2014 to 2018. So in the final quarter, the median was 560 days for a decision. The mean 556, and then the following 5 years, 2019, first quarter 309, final quarter, well, the two final 518 and 425, and then dropping down, just a steady increase and then slight drop in 2022. End of 2022, the time had gone up to 641, so nearly the best part of 2 years for a decision to be made. That divided or considered in the context of just the single competent authority is set out there on the next slide. And obviously that's much higher than the IECA. And you see there, end of 2022, median 697 days, the mean 804, and then this first quarter, 654. Average number is obviously far lower, as I said, IECA. So that provides you with the context. So the legal framework, your international instruments, Article 4, ECHR, EU Anti-Trafficking Directive, and then ECAT, Article 10, dealing with identification, Article 12 with assistance. The principal mechanism by which the UK discharges this obligation, the obligation of identification assistance, is through the national referral mechanism. And that is done through the statutory guidance. And specifically for our purposes on delay cases, you want to look at Chapter 7 and Annex E, and very recently updated. So the latest version is version 3.3, updated on the 10th of July, so only last week. In terms of the process, I'm sure you'll all be familiar with the putative victim of trafficking initially being referred into the NRM only by designated first responders. And once that's done, the reasonable grounds decision should be within 5 working days. There's a recovery period of at least 30 days until you get the conclusive grounds decision. And after that, after a positive conclusive grounds decision, the individual is then usually considered for discretionary leave to remain. Now, the statutory guidance doesn't give any timescales at all, other than setting out that in Chapter 7.9, that a conclusive grounds decision should generally be made as soon as possible. The qualification to that is that it can only be made when sufficient information about the case has been shared or made available, which is generally how the Home Office tends to rely on why it needs more time to make a decision, or why there's been delay to date, that it requires further information or updating information. Annex E of the statutory guidance sets out again that there's no target for the decision within a specific time frame, only once sufficient information is available. Once the competent authority has received sufficient information, the decision is to be made as soon as possible. So really, how long is a piece of string? How soon is as soon as possible? The only timeline that's given on that is that that's to be done once a minimum of 30 calendar days of the recovery period passed. And in respect to children, the relevant reference in the statutory guidance is set out at 14.124. Again, as soon as possible, after at least 30 calendar days, providing there's sufficient interest and it's in the child's best interest. Where possible, before the individual reaches the age of 18, but not at the expense of the child's best interests, if more information is required and not available until after the child turns 18. And the only other further indication about how timescales are applied is at 14.126, which is if the child is subject to criminal proceedings, the SCA should consider the child's case as a matter of urgency, decision only where sufficient information available once the minimum 30 days recovery period has passed. Now, there's nothing else within the guidance setting out at what point that timescale becomes an unreasonably delayed timescale, or what other factors might be factors that feature in deciding when to take a decision, or how to effectively organize that queue of decision making. And if you hang on to that, because that's what we then come to later on when we're looking at the case of FH. So in terms of bringing your judicial review complaining about delay and requiring a decision to be made, a breach of ECAT is justiciable insofar as the UK has sought to implement the provisions through policy. And I've set out there the relevant case law, and specifically MN, which set out that since the national referral mechanism is avowedly intended to give effect to the UK's obligations under ECAT, the guidance must be construed so far as possible to give effect to those obligations. And that was endorsed by the Court of Appeal in EOG and KTT. So the main cases on delay, first of all, begin with RANCEF, European Court of Human Rights case, in which was set out, considering Article 4 of the ECHR, that the requirement of promptness and reasonable expedition is implicit. So it doesn't really take you much further in knowing at what point you should be issuing, at what point you can raise the ground that in fact promptness is no longer features and that actually expedition is then required. And then we have the series of cases beginning with ONH, in which the High Court, it was Mr. Justice Garnham, set out, it's impossible to argue that there was no constraint at all on the period of time the competent authority could spend deciding any individual case. Decisions must be taken in a reasonable time. What is reasonable, however, will turn on all the circumstances of the case, which again comes down to how long is a piece of string, in what case, with what circumstances will the time frame that you're complaining of be deemed to have tipped over into an unreasonable and further an unlawful one. And then followed EOG and KTT in the Admiral Court and then the Court of Appeal, not directly on delay, but because of the delays in the statistics relied on before the court, prompting the Court of Appeal to set out that there is now an extraordinary length of time which it takes for the Secretary of State to reach both conclusive grounds decisions in the case of victims of trafficking and decisions in asylum claims. I am sure that the Secretary of State is aware that solving the problem of those delays would clearly be in the interests of potential and confirmed victims of trafficking, asylum seekers, the Home Office and the courts. And if you have that in mind and think back to the first slide of the statistics where there might be a minimal drop, but by no means one that actually addresses the criticism that's raised there. And then finally on the case law there is the FH case where we were recently granted permission last month, and the new argument run there was that actually there was a practice that in fact, when individuals issued or threatened litigation, that did appear to trigger a decision being taken. So turning first to ONH, and I've put at the top there the date of the hearing. So ONH was heard in November 18. So the evidence before the court then was as at that date, and that's important in terms of seeing how the cases have developed on the statistics since then. Judgment in January 2019 by Mr. Justice Garnham. And what he found was that, and it was accepted, that there were significant delays. The defendant relied on an exponential increase in referrals. It was accepted. The Modern Slavery Unit identified delays as frustrating people's ability to recover from exploitation. And following on from that, the evidence from Professor Katona about delays damaging mental health of the individual putative victim of trafficking and modern slavery and impeding and hindering recovery, that evidence was accepted. Referrals had dropped slightly in 2018. The average time for making a conclusive grounds decision had fallen, but there was a steady rise in decisions. So that's going back in the previous year, which would be 2017. Concerns about the delay for a number of years from all those working with victims, and that refers to those working inside and outside the Home Office, professionals working with victims, and as I read out earlier, beyond asserting that it will all depend on the individual circumstances of the case, there isn't really much more that ONH provided on at what point it will be meritorious to bring a claim and increase the likelihood of succeeding on that claim. It's simply what the circumstances are of the case. What Mr. Justice Garnham also set out was that sensible steps are currently being taken, resources have now been found, which is the same theme that we've most recently seen in our case of FH. It appears from the evidence and the agreed statistics the position is now improving. Well, that was not borne out by the latest statistics. There's no evidence that NRM routinely takes no action. And it was impossible, he held, it was impossible to see irrational or unfair to prioritize support within the NRM on the basis of vulnerability rather than expedition of CG decisions. So that's what the position was at the very beginning of 2019. So then EOG and KTT, and I should actually say ONH, that was a case in which Gemma from Chambers, Gemma Lochran, acted on behalf of the claimant. EOG, this was, again, not directly on delay, but the issues of delay were raised because of the impact on the individuals and how effectively they were left in limbo and without leave. And in EOG and KTT, the statistics then, you have those in the earlier slides on those tables. They showed a delay of 356 days in 2017, 462 in 2018 and 19, a backlog of 9,000 cases. And Mr. Justice Mostyn described those statistics as making for very dispiriting reading. And he set out that the increase in backlog meant that the current disposal rate would take between 2 and 3 years to conclude. The present average of 462 days to dispose conclusively of cases will inevitably worsen given the scale, and that's exactly what has happened. And then he also, referring back to ONH, sets out the data also belies Ganje's projection based on the statistical evidence before him that the number of referrals in 2018 would fall, as well as his projection that the average length of time for making conclusive grounds decision was falling. In fact, it was 356 days and rose sharply. So EOG then goes to the Court of Appeal, successful in the admin court, and then overturned in the Court of Appeal. And this is where I'd set out what Mr. Justice Underhill says about the delay, that there is extraordinary length of time now for the Secretary of State to reach a decision. We were not told that there'd been any improvement. Counsel for the Secretary of State in his oral submissions frankly acknowledged these delays and made no attempt So you'd seen from ONH that the evidence there took us to November 18 with judgment in January. So this now moves on to February 22, so beginning of last year. And there, Lord Justice Underhill says there were other and more appropriate legal routes, i.e. challenge the delay, potentially available to victims of trafficking. I'm sure the Secretary of State is aware that solving the problem of those delays would clearly be in the interests of potential and confirmed victims of trafficking. So that is where it is at. And our Amanda Weston, KC, leading Miranda Butler, appeared in EOG and KTT. So then we get to FH. Now, FH was heard in June 23, and we had evidence taking us right up to, we issued in October 22, so up to near the end of last year. The facts of FH were that they concerned a claimant who was a Kenyan national. She moved to Oman, then Qatar. She was trafficked into the UK, where she was exploited and subjected to severe abuse as a domestic worker. She managed to escape and was referred into the NRM by the police at the very beginning of August 19. Over 3 years on, having had a positive reasonable grounds decision just over 2 weeks after her referral, she had still no decision on the conclusive grounds. So the PAP was sent out in October, and then from that time, the Secretary of State just jumped about with different dates and different reasons for providing us with a decision. But what we set out from the beginning, within the pre-action letter and then within the grounds, was to say, we know that when proceedings are either threatened or brought, that seems to get somebody into action and prompt a decision to be made. And so what appears to be the case is that that action isn't just a one-off, but all those, or many of those acting for victims of trafficking, have seen this practice develop, where actually, unless as an individual you're able to access lawyers, and those lawyers in turn are able to secure legal aid, and we all know the real difficulties with that. So unless you can get lawyers, you can get legal aid, those lawyers can bring a claim, that is your best chance, because actually that does very often result in a decision. And sure enough, first new date we were given without any proper explanation. It just seemed to have been more of an afterthought, and to have something provided, was that we were told that we would receive a decision at the end of June. So we were told 8 months. We asked why 8 months and on what basis was the 8 months arrived at, but didn't receive a decision on that or any explanation beyond being told, well, that would be after the asylum interview, which was obviously the wrong approach. So we then issued and then received the acknowledgement of service, which then said, in fact, having been told we'd get our decision at the end of June, then delayed it, but gave a very specific date of the 11th of August. At this time, not on the basis of the asylum interview and the timing of the asylum interview, but on the basis that the writer asserted that they needed more information from the claimant. When we pointed out that they didn't need any more information from the claimant, because all the information that they did need had been provided by way of various witness statements and previous accounts and her interview answers, her initial interview records, they then said, well, okay, we do have the information, we do have all the information. And so they jumped back, not quite the beginning, not June, but the 11th of June. And again, with no other basis beyond giving that date. Then in February 23, they changed their mind again and said, well, actually, because the asylum interview is in February, we can now give you a conclusive grounds decision within 3 months. So by the 10th of May, very specific, that's the time that it would take. And again, earlier than the previous dates that they'd given. The interview was then had to be rearranged because there were interpreter problems. That same month in February, permission was refused because they had set out, the defendant had set out that actually we would receive a decision within 3 months. And so the judge on the paper said, it's not my role to look on the macroeconomics and look at how the Home Office arranges its system for deciding cases. The judge recognised that it was all unfortunate, but permission was refused. And then we renewed, and the date for renewal was listed on the 21st of April. And a week before the renewal, we were provided with a positive conclusive grounds decision. So not in any way tying into any rationale to the dates we've been given previously, but coinciding with the next time that the Secretary of State would be required to answer to a judge in court at a hearing and explain the delays. So obviously, there was some connection between getting the matter into court and the Secretary of State deciding to actually take action and make a decision. And what we complained of was that exactly what we had foreshadowed and exactly what we had anticipated was in fact what had then come to be the case. And in raising that argument, and directly before the renewal hearing, the Secretary of State relied on a witness statement. And that witness statement revealed some very interesting evidence, which we leapt on. And that evidence went beyond the statutory guidance. So at the start of my talk, when I was taking you to the slides, I asked you to bear in mind what is set out. I'll go on speaking while we try and find what's happened to the slides. Well, I asked you to have in mind what the statutory guidance said and the circumstances in which there are certain priorities given. So when a child is involved, or when there are criminal proceedings, or when in fact further information is required, and the here we go, we're going to get the slides sorted out. When further information is required, and that information is such that it's only until after the child turns 18 that that information is available. But what it doesn't say in the statutory guidance is that if there is a legal challenge about ongoing delays, that in fact would trigger a decision. So the evidence was provided in this statement, and what the author set out was that where there was operational, so the wording used was where there was operational flexibility, he referred to ongoing legal challenges issued on alleged delay being a factor. So what he was essentially saying was that we don't really have any systems in place, but if there's not only if there's litigation, but if there's litigation concerning delays, then actually, if we have the flexibility, we can do something about it. Now, that's not in the statutory guidance. That's not something that had been disclosed before. So we said that actually what that amounts to is that you have an unpublished policy, because you must be somehow, first of all, you must have obtained that. In order to put that into your witness statement, you must have obtained instructions on this. You must have been communicating this to your caseworkers. Else, how would those caseworkers know that in certain circumstances, litigation can prompt a decision being made? So you should have it up now again. So you see there, ongoing legal challenges issued on alleged delay being a factor. That brought together our argument from the outset, going back to the PAP, saying we know that when we bring this PAP, you'll either give us a decision now or you give us a timescale now. And we also know that just before we're in front of a judge, you will give us that decision, because that's the only thing that seems to work. And we got the decision. We got the positive conclusive grounds decision. So we came before, we had our renewal hearing on the 9th of June, and it came before Mr. Justice Eyre, and he was not convinced at the outset, because he took the view that actually how was our case different from O&H, which had been dismissed, and the same witness statement referred to further resources, and so he could not see, having considered the papers before him, that there was a point that distinguishing FH from ONH, but in fact, further to hearing submissions from both sides and considering the witness statement, he said, no matter how you label what is being said about the impact of legal challenges, and no matter whether the claimant says this is an unpublished policy or not, or the defendant says that in fact too much is being read into the witness statement, what he held was that there were real merits of success on this case. He said that the bringing of a claim, and just pausing there, we had extensive witness statements from other solicitors and organisations working with victims of trafficking. And he said what that showed, and in fact we had our own case in our own circumstances, was that bringing a claim triggered a decision, and it moved the case up the queue, so that the system operated in such a way that those starting proceedings reduced the time to get a decision, and that was arguably irrational. And so on that basis, he granted permission. So where do we go from here? Next steps from here. FH is due to be listed, it's likely to be listed at the end of this year, and it's down for a 2-day hearing. We have our positive conclusive grounds decision. We also have very recently our grant of asylum. In terms of all those other delay cases out there, the first thing I would say is that it's, without stating the obvious, it's important even before your pre-action to set out in your pre-action not just your audit trail, but your request for a decision to be made, highlighting any previous requests, highlighting the previous evidence that has been submitted, so that the defendant's more difficult for the defendant to come back and say, well, actually, in accordance with the statutory guidance, we don't have sufficient information. So you knock those points out. Rely on FH in your PAP. Rely on the latest statistics that I took you to, and you have the link to those. Set out the impact on your client, because ultimately the court will also consider, obviously, the individual circumstances of the case. Generally, we're sending out more PAPs, and we're seeing that we are being told a decision will come in 3 months. I mean, if you are able to get funding on an assurance that a decision will come in 3 months, and I expect you're not, I still think that that would be premature to issue. But if they breach on that timetable, and given the extent of the previous delay and the vulnerability of your client, I would then consider issuing. Press on the explanations for the timescales, because as you saw in our case, they just jump back and forth between dates. And actually, if you go beyond or even at face value, if you look at the dates and the reasons, they just don't stack up. And all of that undermines whatever system, insofar as there's any system in place, how that operates. And as I say, they appear to just come from thin air. And if you have cases with the same pattern of litigation triggering a decision, please let us know. And on that note, I'm going to come to my last slide, which is to say that this really is, right from beginning, right from going back to ONH, it has been the most enormous joint effort. I've set out there the email from Ugo, who I should pay tribute to her, because she's worked on these since before ONH, and I took you back to that being in 2018. And thanks to the many organisations that gave us evidence, because we relied on that evidence on still pushing at that door so that we achieve the finding of unlawfulness on delay. And hopefully we will be successful in the substantive hearing. So meanwhile, watch this space. And if you have cases raising these points and you see a response when litigation is threatened or brought, please let us know, because that all strengthens the arguments that we will then run. Thank you very much.
Thank you so much, Nicola. That was really super interesting. I really thought it was very, sort of really insightful, looking at those statistics going through over past 5 years or so, and then sort of the challenges that have come through that and where we stand now. And obviously, it looks really important that there's quite a lot of people who've come together and of bringing these cases forward. So thank you. Without delaying any further, I am going to hand over now to Ronan Toal, who's going to discuss public order disqualifications under the Nationality and Borders Act 2022. And these essentially function to deny victims of trafficking the protections to which they are entitled, particular people who are foreign national offenders, but that can often extend out even further, in particular to circumstances where individuals have been trafficked into forced criminality and have referrals into the NRM as a consequence of that. So Ronan is also a barrister here at Garden Court. He's practiced immigration and asylum law since 1989. He doesn't look that old. He's appeared in leading cases, including in relation to psychiatric evidence. That includes KV Sri Lanka in Supreme Court back in 2019, and MN and IXU in the Court of Appeal back in 2020. Ronan is an editor of McDonald's Immigration Law and Practice, which is, in my view, the leading practitioner's text. He's also ranked #1 for immigration law in the Chambers Bar Guide. So without taking any further time from Ronan, I'm going to hand over to Ronan.
Thank you very much. So I get the impression that the Home Office is industrially producing public order disqualification decisions. They're making these decisions on a mass scale, taking advantage of the powers that they've been given by the Nationality and Borders Act. So for the purpose of trying to challenge such decision making, the starting point, I would say, is the Council of Europe Convention on Action Against Trafficking, and in particular Chapter 3 of that convention. I think that's the place to start looking to find a challenge to these decisions. Chapter 3 is entitled Measures to Protect and Promote the Rights of Victims, Guaranteeing Gender Equality. And again, the title of that Chapter 3 is important. And obligations that the Convention contains in Chapter 3 include, first of all, and importantly, Article 10, which is the obligation to identify victims of trafficking, and also the important obligation where there are reasonable grounds to believe that a person may have been trafficked, an obligation not to remove the individual until the identification process is complete. Then there's Article 12, which obliges states to adopt such measures as may be necessary to assist victims in their physical, psychological, and social recovery. And that includes at least the provision of accommodation, support, and medical treatment. There's Article 14, which is an obligation to issue a residence permit to victims of trafficking in certain circumstances. That includes where their presence is necessary to assist the police or a judicial process relating to their trafficking, or it's necessary owing to their personal situation. There is Article 15, which is an obligation to enable victims to pursue claims for compensation. And there is Article 16, which is the obligation when removing a victim of trafficking to ensure that it is done with due regard for their rights, safety, and dignity. And also an obligation on the state to make its best effort to favour the reintegration of victims into the society of the state of return. So none of those obligations are qualified in any way by reference to the conduct or the character or any other quality of the victim. I mean, you might have noticed that in reciting those obligations, I missed out Article 13, which is the obligation to provide a recovery and reflection period of at least 30 days, where there are reasonable grounds to believe that the person is a victim of trafficking. And during that 30-day period, the potential victim of trafficking may not be removed from the jurisdiction. That is the only one of the obligations that I'm referring to which is qualified by reference to the individual's conduct. And the qualification to the obligation to provide a rest and recovery period during which the person may not be removed is that the parties are not bound to observe this period if grounds of public order prevent it, or if it is found that victim status is being claimed improperly. So I think that is very important. that none of these obligations are qualified, save for the qualification in the Article 13 recovery and reflection period. So that's the obligations under the Convention. How are those able to be relied on in domestic legal provisions? Well, first of all, there is the Home Office's repeated assertion or admission that it intends to give effect to obligations under the Trafficking Convention. And so the Supreme Court in MS Pakistan held that the Secretary of State has consistently accepted that the NRM should comply with ECAT, and it would be a justiciable error of law if the NRM guidance did not accurately reflect the requirement of ECAT. I'm sorry, I should have mentioned before or as I started, you'll see that there are no slides from me other than this slide here, telling you who I am. I have made some notes, and I'm talking from these notes, and the notes that I've made will be available together with the recording of this session. So they should be distributed not long after we've finished. So the NRM, it's been held repeatedly that the Secretary of State's guidance is intended to give effect to the UK's obligations under ECAT. And as Nicola mentioned, the most recent iteration of the guidance comes from almost exactly a week ago, version 3.3 of the statutory guidance. The statute, that's the Modern Slavery Act 2015, section 49, obliges the Secretary of State to give guidance concerning various matters, including the procedure for deciding whether a person is a victim of trafficking, and the provisions that are made to assist and support victims where there are reasonable grounds to believe that they're a victim of trafficking. More powerful, I would say, than the essentially legitimate expectation that one has arising from statements by the Secretary of State that she intends to give effect to ECAT. A more powerful way of giving effect to those obligations in domestic law is through Article 4 of the Human Rights Convention. And as you know, in Rantsev in Cyprus, the European Court of Human Rights decided that trafficking, within the meaning of Article 4 of the Trafficking Convention, fell within the scope of Article 4 of the ECHR. And that has been confirmed by the Grand Chamber in the case of SM against Croatia. So what that means is that Article 4 of the ECHR imposes a number of positive obligations upon states, and they are, by virtue of the Human Rights Act, Section 6, for practical purposes binding as a matter of domestic law. That's what the Court of Appeal said in MN and IXU. Now, the Strasbourg Court has repeatedly referred to the Council of Europe Convention Against Trafficking for the purpose of specifying what positive obligations arise under Article 4. So in the case of Chowdhury against Greece, for example, the court said that that the positive obligations must be construed in the light of the Trafficking Convention. And the court is guided by the Trafficking Convention and the manner in which it has been interpreted by Greta when it comes to deciding what are positive obligations under Article 4. There's a slight word of caution on this theme introduced by the Court of Appeal in the TDT case, where it said that there is no automatic read across between ECAT and Article 4. But nevertheless, as the Court of Appeal said in MN and IXU, the case law shows that the content of the protection duty under Article 4 is to be derived from the provisions of the Trafficking Convention. And thus, obligations under Chapter 3 of the Trafficking Convention will be directly enforceable to the extent that they correspond to positive obligations under Article 4 of the ECHR. So, whilst there's no automatic read across from Chapter 3 of the Trafficking Convention into Article 4, there is a fairly strong correlation. I mean, there is no doubt going to be debate as to exactly how much Chapter 3 of the Trafficking Convention corresponds to Article 4, but there is a substantial degree of correspondence. So what then are the positive obligations under Article 4? I mean, they've been divided up into three broad headings. First of all, there is the systems duty, which is the obligation on the member states to establish a legal framework prohibiting and criminalizing trafficking in human beings. Then there is the investigation duty, which is the obligation on states to investigate possible situations of trafficking and to bring a prosecution if possible. And then thirdly, which is the aspect of the positive obligation most important in this context, is the operational duty. And that is a duty, referring again to the court in Chowdhury, a duty to take steps to protect individual victims of trafficking. And that includes, on the one hand, preventative measures, and on the other hand, protection measures. And protection measures, so the court said in Chowdhury, include facilitating the identification of victims by qualified persons and assisting victims in their physical, psychological, and social recovery. And that way of describing the protection measures resonates very closely, I would say, with the heading of Chapter 3 of the Convention Against Trafficking. And it chimes also with the obligation under Article 10 to identify victims of trafficking, and with the obligation under Article 12 to assist victims in their physical, psychological, and social recovery. So that's Article 4. There's a further important way in which positive obligations under Article 4 have been given, or positive obligations under the Trafficking Convention, rather, have been given domestic effect. And that is by way of primary legislation. And I'm referring here to the Nationality and Borders Act. So the Nationality and Borders Act gives partial effect in primary legislation to some of the obligations under the Trafficking Convention. So Section 50A of the Modern Slavery Act, that was brought in by the Nationality and Borders Act, obliges the Secretary of State to secure that any necessary assistance and support is available to an identified potential victim. And the reference to necessary means necessary for the purpose of assisting the person in their recovery from any physical, psychological, or social harm arising from the conduct that resulted in the reasonable grounds decision being made. So clearly that gives at least partial effect to Article 12 of the Trafficking Convention. Then there's Section 61 of the Nationality and Borders Act, which gives effect to Article 13. That's the provision for a recovery and reflection period. Section 65 of the Nationality and Borders Act gives partial effect to Article 14, which is the obligation to consider granting a residence permit to a person where the grant of such a permit is necessary owing to their personal situation. So that's the good news. That's what the statute gives by way of obligations under the Trafficking Convention. The bad news, however, is that what the law gives with one hand, it takes away with the other. And that is by means of Section 63(2) of the Nationality and Borders Act. So if Section 63(2) of the Act applies to a person, then the following cease to apply. First of all, there is the prohibition of removal of the person arising under Section 61 and 62 of the Act. That is the prohibition on removal during the recovery and reflection period. Secondly, any requirement to grant the person limited leave to remain, that is disapplied if Section 63(2) applies. And then thirdly, any duty to provide support and assistance to a potential victim of trafficking under section 50A of the Act, that is disapplied if section 63(2) applies. And as well as that, this is not in the statute, but it's in the statutory guidance. If a public order disqualification decision is made against a person, then a conclusive grounds decision will not be made in respect of that person. So the legislation thereby disapplies the obligation to identify victims of trafficking. Section 63(2), it is important to note, is a discretionary provision. So the Secretary of State is not obliged to disqualify a person from those various protections if it turns out that the person is a threat to public order or is claimed to be a victim of modern slavery or human trafficking in bad faith. What the statute gives to the Secretary of State is a discretion to disapply those provisions if the person is a threat to public order or claimed to be a victim of trafficking in bad faith. So then section 63(3) specifies the circumstances in which a person is a threat to public order, and thus the circumstances in which the discretion to disapply those provisions arises. And the most important circumstances in which a person is regarded as a threat to public order are circumstances where the person has committed one of a range of criminal offences. And a lot of those offences are specified in the Nationality and Borders Act directly. But the Act also makes reference to the Nationality, Immigration and Asylum Act 2002 specification of particularly serious crimes order of 2004. And if a person has committed one of those offences, then they're also liable to be treated as excludable from protection because they are a threat to public order. That instrument I've just mentioned, the original source and purpose of that instrument was to assist in the application of section 72 of the Nationality, Immigration and Asylum Act, which is the section which gives statutory effect, or rather gives statutory shape to Article 33 of the Refugee Convention. That's the provision enabling a person who is a refugee nevertheless to be removed if they have committed a particularly serious offence. And the order that I've mentioned is the order that lists what are particularly serious offences. So first of all, in the statute, a person is to be treated as a threat to public order if they are a foreign criminal within the meaning of the UK Borders Act 2007. In other words, if they've been sentenced to imprisonment for at least 12 months. But if they've been sentenced to imprisonment for a period of less than 12 months for one of the offences specified in that order with the very long name that I've mentioned, then they are also to be treated as a threat to public order. And that statutory instrument lists offences that include, for example, possessing a Class A or B drug with intent to supply, or occupying premises where the production or supply of a controlled drug is knowingly permitted. And those, of course, are two offences which a lot of victims of trafficking get caught up in. So if you're convicted and sentenced to a period of less than a year for one of those offences, then you may be subject to a public order disqualification. The statutory instrument goes even further to include offences of burglary and offences of theft. So if you get convicted to a period of imprisonment of less than a year for theft, then you can be potentially disqualified from these protections. Another category of people potentially disqualified are those excluded from the Refugee Convention under Article 1F. And then there's also people who otherwise pose a threat to national security. So those are people who are excludable on public order grounds. The bad faith ground is not elaborated in the statute, but what the statutory guidance says about the bad faith ground is that an individual may be considered to have claimed to be a victim of modern slavery in bad faith, where they or someone acting on their behalf, having knowingly made a dishonest statement in relation to being a victim of modern slavery. And what's interesting and troubling about that is that it would seem to embrace a situation where somebody has made what turns out to be a dishonest statement in relation to being a victim of modern slavery, and yet the person may still be a victim of modern slavery. It's not saying that the entire claim to be a victim of modern slavery has to be dishonest. It's simply that a statement made in relation to the claim is dishonest. So those are the two potential grounds for being disqualified: public order and bad faith. There is a very important paragraph or passage in the explanatory notes to the bill that became the Nationality and Borders Act, which explains the Secretary of State's explanation of, understanding rather, of the Convention Against Trafficking and how that is consistent with the public order disqualification. What paragraph 597 of the explanatory notes says is that public order disqualification is justified on the basis of the Convention Against Trafficking, because that convention contains provisions for an exemption to the protections conferred during the recovery period on public order grounds, or if it is found that the victim's status is being claimed improperly. This clause puts these disqualifications into primary legislation. I mean, I think that that is totally wrong. It's completely and obviously wrong, because the Secretary of State is right and entitled to say that Article 13 of the Trafficking Convention, that's the provision for arrest and recovery period, the Secretary of State is entitled to say that that is qualified, and that the protection conferred by Article 13 can be withdrawn or denied on public order grounds, or if it's found that the victim's status is being claimed improperly. But that's as far as the qualification in the Trafficking Convention goes. It applies only to the rest and recovery period under Article 13. It does not read across into the other articles I've mentioned. So the Article 10 obligation, for example, to identify victims of trafficking, or the Article 12 obligation to support and assist victims of trafficking. None of those are subject to an Article 13 derogation. So then the next thing I want to talk of is the procedure that the Secretary of State will adopt or has adopted for making public order disqualifications. And that is to be found in the statutory guidance, beginning around about paragraph 14.231. So the first step, as far as the potential victim of trafficking is concerned, is that the Secretary of State will issue to a British citizen or to a non-detained foreign offender whose disqualification is being considered a letter saying that the Home Office is minded to apply the public order disqualification, subject to any relevant information being provided within 10 working days. So if the potential victim of trafficking is British, and if the potential victim of trafficking is a non-British citizen but not in detention, that person will have 10 days in which to make representations to the Home Office as to why the public order disqualification should not be applied. However, for a potential victim of trafficking who is a foreign national offender and who is in detention, either serving their custodial sentence or detained under Immigration Act powers, they will not have the 10 days in which to make representations, so long as the Secretary of State thinks that she's got enough information already to hand upon which to base the decision whether to disqualify the person. So that seems to me to be procedurally highly unfair and challengeable on grounds of procedural fairness, the ground that one has a right to make representations before so significant a decision is made against the individual. And it's also potentially challengeable on discrimination grounds, that a British citizen who is in detention serving a custodial sentence will not be denied an opportunity to make representations, whereas a foreign national offender will be denied the ability to make representations. So if the individual has been given 10 days in which to make representations, the guidance also says that it is not possible to seek an extension to the 10-day time frame unless exceptional circumstances apply. It's paragraph 14.245. And then it goes on to say that information that is received outside that time frame will not be considered unless an extension was granted. And just to show how amazingly fair she is, the Secretary of State says that that will equally work to the disadvantage of the Home Office if information comes to light outside the 10 days, which shows that the individual should be disqualified. So if it turns out that the individual is also a murderer and a torturer, but the Secretary of State didn't realise that until 10 days had gone, she will close her eyes to that information. The other thing that the guidance says, the guidance makes provision for the Secretary of State to reconsider negative reasonable grounds and negative conclusive grounds decisions, that representations can be made that there's new information come to light or that there was something wrong with that decision, so it should be reconsidered. But the guidance expressly separates public order disqualification decisions from that procedure, so that there is no provision, or rather the guidance provides that she will not reconsider public order disqualification decisions. So that is the procedure. In terms of how the discretion is to be exercised, that is the discretion to make a public order disqualification decision if an individual is potentially liable to such a decision being made, either because they're a threat to public order or they've claimed trafficking victim status in bad faith. What the guidance says is the starting point is that an individual who meets the public order definition is a threat to public order. The decision maker must then consider, on the evidence available, whether the individual's need for modern slavery specific protections outweighs the threat to public order posed by the individual. There is a high bar for the need for modern slavery protections or support to outweigh the threat to public order, with more weight given to the public interest in disqualification. So that, in general terms, is how the discretion is to be exercised in accordance with the guidance. And there is slightly more detail given in the guidance itself as to the way in which the Secretary of State will weigh up various factors. But it's probably important to highlight from just that little passage that the key balancing exercise that the Secretary of State will conduct is between, on the one hand, the putative public interest in disqualifying the individual, and on the other hand, the individual's need for modern slavery specific protections. So if one is anticipating a possible public order disqualification decision being made, or if one has got the 10 days in which to make representations, one of the most important themes to address is the nature and extent of the individual's need for modern slavery specific protections. So that's the decision-making process and the way in which the Secretary of State says that she will exercise discretion. I mean, I would say that there are a lot of good arguments for saying that a decision in an individual case to apply the public order disqualification would be incompatible with the UK's obligations under the Convention Against Trafficking, and therefore also in breach of the positive obligations under Article 4. So first of all, there is, going back to the beginning, the obligation to complete the process of identifying a victim as, the process of identifying a person as a victim of trafficking, and the obligation not to remove the person whilst that process is undergone. That is an obligation under Article 10, and it's one of the obligations that the European Court of Human Rights has referred to as being a positive obligation under Article 4. That's the Chowdhury case. So the making of a public order disqualification and the cessation of the identification process is flatly incompatible with Articles 10 of ECAT and Article 4 of ECHR. Then there's the obligation under Article 12 to support and assist the person in their physical, psychological and social recovery, which begins once there are reasonable grounds to believe the person to be a victim of trafficking. Again, the derogation from that obligation is flatly incompatible with Article 12 and Article 4. There's the obligation to grant leave to remain if the person's stay is necessary owing to their circumstances or in relation to an investigation or prosecution. The derogation from that obligation is again flatly incompatible with Article 14, and I would say also with Article 4. And there's the obligation not to remove a victim of trafficking unless done compatibly with that person's dignity, safety, and human rights, and with having made, the state having made its best efforts to favour the person's integration. Again, the statutory derogation from those ECAT rights, I would say, is flatly incompatible with ECAT and flatly incompatible with Article 4. And I would say that for the same reasons, there are very good arguments for saying that the statutory guidance is unlawful because it directs the Secretary of State to exercise her statutory discretion in a way that is incompatible with Article 4 of the ECHR. And finally, I'd say that the procedure that the Secretary of State has designed for making these decisions is unfair, at least when it comes to incarcerated non-British citizens. So I would say that for those reasons, very, very good challenges available to individual public order disqualification decisions and to the statutory guidance that sets out how the Secretary of State will exercise the powers that have been given by that Act. I will just finish by just mentioning what is in store in the Illegal Migration Bill. So the primary provision in the Illegal Migration Bill is the obligation imposed on the Secretary of State to make arrangements for a person's removal if the person required leave to enter or remain and entered unlawfully without having come directly from a country of feared persecution. Clause 2.1 of the Illegal Migration Bill applies to such a person. And what the bill goes on to do in relation to people to whom Clause 2.1 applies, and in respect of whom there are reasonable grounds to believe that the person is a victim of trafficking, is to oblige the Secretary of State to disapply the protection against removal that the person would otherwise have under sections 61 and 62 of the Nationality and Borders Act. It also entitles the Secretary of State to revoke a person's leave to remain if they've been granted leave as a victim of trafficking, if that grant of leave is the only reason that the person is not somebody that the Secretary of State has to remove. And it obliges the Secretary of State to make a public order disqualification decision against a person if the person has been sentenced to any period of imprisonment for any offence. So that's the good news coming down the road, coming down the line in the illegal migration bill. So on that happy note, I will finish.
So that's it's a very interesting insight into public order disqualification and into some of the things that we've got coming up. And certainly looks like section 63 in particular, where it rises of cart and horses through ECAT and Article 4, and indeed procedural fairness. So we do have a short amount of time for questions. We don't have an awful lot of time, but about 10, 15 minutes or so. So if you do have any questions, do pop them in the chat now. We already have had a couple of questions, and I think they've been answered as we've gone through. So first of all, just to remind you that this webinar is being recorded, so you will be able to go back and look at it in future. And also the slides and the notes will be circulated around everyone who signed up today. So those features will be made available. I'm just going to quickly read out a couple of questions that we've already had and some of the answers that have been given. So one of the questions was, could the outcome of the challenge to delays in the NRM mechanism, could it be that the Home Office simply now refuse to prioritise those cases where judicial review proceedings have been commenced? And the answer is, essentially is that it is something that they could do, but equally it then means that delay continues and adds to the delay that has prompted those proceedings to be brought in the first place. And also within the grounds that have been granted permission recently, there's extensive evidence on that practice already being affected. So the practice of public law proceedings facilitating a response. Another question that was posed was the question of whether or not there is a published policy on the link between the NRM and asylum decisions. And is the questioner's understanding that they were not dependent on one another, but in practice it seems that they're often considered in tandem and one relies on the other. And that's true, you do often see that in practice, and that is absolutely right. And what Nicola has written here is that to delay because of the asylum claim or need for more information when it's not needed, that unlawfully overlooks the positive obligations to investigate in the national referral mechanism. Also, is not necessarily a link between the person's status of a victim of trafficking and their entitlement to refugee leave. So in JP and BS 2019, the court accepted that there was no lawful basis for the scheduling rule, which i.e. this was the defendant's policy of deferring a decision on discretionary leave until after the decision has been laid on other forms of leave, including refugee leave. So scheduling is inconsistent with ECAT and contrary to Article 14 of the European Convention. So we did have one sort of question stroke observation that's been put in, which may well be best directed at Ronan. So the observation here is someone's suggested that Article 13.3 doesn't provide a discretion to the SCA to deny an R&R period. More than an R&R period, rest of recuperation period can be denied if grounds of public order to prevent that. The suggestion is that it could only be denied where it's not been granted. So, for example, where a person has been removed. I don't know whether you have any observations on that.
My understanding would be that Article 13 potentially comes into play where within a day or two of a positive reasonable grounds decision, there is a conclusive grounds decision. So if there's a negative conclusive grounds decision, then the individual by virtue of Article 13, can stay for at least 30 further days. If there is a positive conclusive grounds decision, but the state decides that there is no need for the individual related to their trafficking to stay in the UK, in other words, that the individual is somebody who is removable and none of the trafficking convention obligations require that the individual be permitted to stay, then that individual would be removable, say on day 3, if on day 2 the positive conclusive grounds decision is made. They'd be removable on day 3. But Article 13 gives them another 28 days or 27 days of rest and relaxation. It seems to me that the public order and bad faith proviso to Article 13, its effect is goes no further than to deny the entitlement to stay for the whole of the 30 days to those individuals, namely the person in respect of whom there's a negative conclusive grounds decision, or the person with the positive conclusive grounds decision, but no need for them to remain in the UK. To me, that seems to be as far as the proviso goes, because even if somebody has got a positive reasonable grounds decision, but they are a threat to public order, the Article 13 proviso would deny that person the 30 days rest and recovery period. But Article 10 would prohibit the state from moving that individual for as long as it takes for the identification process to be concluded, even if it's 566 or 807 days, however long. Article 10 would operate to bar that person's removal, and Article 13 has no impact on that at all, I would say. And the Secretary of State has just willfully, I would imagine, willfully and deliberately misconstrued Article 13 as having a much broader application outside the limits of the inclusionary provision in Article 13.
Thank you, Ronan. Another question is whether or not there have been any update on the judicial reviews already granted permission on the public order disqualification point. So I understand there are a couple of cases that have permission. Beyond that, I personally don't know anything further.
I don't either. I've been instructed by Ben Goldberg in quite a few of these cases. And I mean, they've been issued for some months, but no decision yet as to grant or refusal of permission. But as I said at the beginning of it, it seems to me that these decisions are being mass produced. So I would guess that there is a very lengthy queue in the High Court of cases that are presumably being managed in some way or other.
Yeah, it definitely seems to be the case that a lot of it's very easy to give these out, but then actually dealing with the actual reality of, you know, the next steps for the Secretary of State are obviously going to be much more difficult for her, I think. Okay. I don't believe we have any more questions. So unless anyone wants to pop something in sorry, we do have one more here. So if a potential victim gets support all the way up to a conclusive grounds decision, what is the benefit of wanting that conclusive grounds decision to be made quicker, as that could end their support?
Well, I mean, obviously the benefit of that is as soon as you get your conclusive grounds decision, you can then be considered for discretionary leave. And so once you have that, you should get your discretionary leave and then support will follow. So as well as no longer having the uncertainty and being in a limbo situation, that's why it's so essential that you have your decision on it.
And also Article 12, which is the provision for giving support, you get you only get the sort of skeletal aspects of the support obligation when you're only a reasonable grounds person, whereas you get a much broader array of sort of protection and assistance and support once you get a positive conclusive grounds decision.
We do have a couple more. So the NRM delay statistics count as a period of, do the NRM delay statistics count for the period of delay for the CG decision from the date of an NRM referral?
Yes, so you're speaking then about a different type of delay. So indicators of trafficking are raised and no action is taken. Yes, I mean that's separate. So the delay that we were running was the delay from the time of the reasonable grounds decision, and predominantly the delays are then in providing the conclusive grounds decision. So I mean, an answer, I think yes. I mean, there will be unlawful delay if no action is taken, but also there's a breach there of the positive obligations to identify and then also provide support that flow from that as well.
I have another question here. So could you give any examples of public order disqualifications that have been issued so far? So it'd be interesting to know why people have been prevented from support and whether it's entirely unrelated to previous convictions or concerns.
I mean, I think the guidance says that any offences that fall within those broad headings that I mentioned when I was talking about what is a public order disqualification, any offence that falls within those broad categories, regardless of when it was committed, however long ago it was committed, makes the individual potentially liable to exclusion. And they do seem to be fairly systematically excluding, or at least considering excluding, anyone who has one of those offences in their history. And I mean, interestingly, the guidance to the extent that it tells the decision maker how to make these decisions, it says that one of the considerations that they should have in mind is whether there is a nexus between the person's experience of being trafficked and the committing of the offence. And one would have imagined that if the guidance would say that if there is such a nexus, then almost certainly the individual should not be excluded or disqualified. But in fact, the guidance says that that's a matter to which only limited weight need to be given. So amazingly, even if somebody gets, say somebody is prosecuted for possession with intent to supply in a county lines scenario, or found in a cannabis factory, and they are given a sentence of imprisonment, say of any period of time, a couple of months, 4, 5, 6 months, that individual is potentially liable to be disqualified. And given the nature of the process, it seems that they will almost inevitably be identified as a candidate for disqualification. That's even if the offence was committed because they're a victim or they were being trafficked.
Thank you, Ronan. On that note, I think we will wrap up. Wrap up for 2 minutes before 6:30. So I think that's quite good. Well done, everyone. So thank you very much to Nicola. Thank you very much to Ronan.
Thank you very much, Stephen.
Yeah. Thank you, everyone, for attending this evening, and hopefully see you all soon.